Good morning, and this is Hap May with the Legal Play.
I'm Chelsea El-Azzi, Hap's associate. Hap, we have somewhat of a large overall topic today that we'll
Okay,
we'll see how it flows and progresses. I know the questions I want to ask, and I think you will know the answers.
I hope so.
I'm pretty sure you will. Okay, so you specialize in bankruptcy tax, but you have a lot of clients that are just, you know, deal with bankruptcy issues. So this topic today is just overall kind of what is bankruptcy? Who is it for? Why does it exist? So I kind of want to start there. Is maybe like the government created bankruptcy as an option to kind of, you know,
All right.
help people and
Okay.
safeguard.
All
So
right.
so why does bankruptcy exist? Why is that even an option for people? What's it there for?
Well, okay. To start out with, bankruptcy is for people that people and businesses who just can't pay everybody. It is actually something was started in English law, although it's much different in English law. In English law is they had a creditor's remedy, where a creditor can put somebody into bankruptcy. So there's a court that then has control over who gets paid and what happens to the debtor's assets. In America, it is usually a debtor's tool. When a debtor gets to a point, debtor, whether it's a company or an individual, gets to the point where they cannot pay all their creditors. And without bankruptcy, you would have a situation where you have 10 creditors, each fighting each other, and a impossibility for the debtor to be able to deal with all 10 of them. That, while it may be able to deal with one, creditor to keep them from taking all their assets, another creditor may come in and take those assets. So you need some organized way where there is a process whereby the debtor and all the creditors can sort of get into one process and figure out what.
I think it's interesting in England. Is it still like that in
It
England?
is very much still like that.
Because I mean, hundreds of years ago, I suppose, if you just had debts to everybody and you couldn't pay it, they'd just throw you in jail.
There was a thing called debtor's prison. We actually had that in the United States until about 1890.
Like, stop making deals with people, stop borrowing money you can't pay back. We're gonna put you in jail, and then we're gonna take all your stuff and maybe try to sell it.
And there was this indentured servitude. They were somebody wanted to come to the United States, so they put themselves into debt to somebody, and they had to work for them for 5 years.
That's
And
okay.
there's a whole long history
Okay.
to bankruptcy, but
Okay.
there is in bankruptcy just kind of a story, the automatic stay, which basically when a debtor files bankruptcy, at least initially and automatically, creditors cannot take any collection action until the court later on approves them doing so. And that's a standard procedure that lawyers and bankrupt persons and creditors involved in bankruptcy get used to dealing with. But when you go back in history and realize that if somebody filed bankruptcy, that meant they got out of debtor's prison.
Okay.
The whole concept of an automatic stay becomes much more down to earth.
So I like this because I've spoken with a number of people, and some people I think have this, and it's probably from the news when there's this big, financial mogul that in history has filed bankruptcy, and they are still doing well. They are still thriving, and their face is on the magazines of the business journals, and it's like, well, didn't they file bankruptcy? I don't understand. How are they still rich if they filed bankruptcy? And so I don't know who I have no names exactly.
There are those, and that is the frustration to many creditors is the fact. But one of the reasons for filing bankruptcy is protect future wages. So if I have I am pretend for a minute I'm a really talented person that can make lots and lots of money. Whether it's that I'm just a great businessman or a good baseball player.
Okay.
And I've got debts that I can't pay, so I can file bankruptcy. I can take the assets that I've got and pay those creditors what assets they have, and then be released so that I can go on and continue to earn money and, either have a fixed amount I have to pay my creditors as part of a plan, or be completely absolved of debts prior to my bankruptcy, and then I can go forward. And if there wasn't that ability, then somebody who who could be a productive member of society would have no incentive to go work if the only reason he was going to work was to pay his creditors, and there was nothing in it for him in the process.
Okay, so it's almost like incentivizing them to continue earning and being profitable and productive.
Yes, and it's a policy
Okay.
decision. I mean, let's come out with some system where a bankrupt person can file bankruptcy. Some money goes to the creditors, and then the bankrupt is released. He gets his discharge. He can go forward.
Okay. Is there ever a scenario where you can get richer coming out of bankruptcy? Because I was asked this question is how can I get rich by filing bankruptcy? And I was like, it doesn't work that way.
No, it doesn't. It doesn't. It doesn't work. It does. It does. It does not work that way. You have to be rich to start with,
or at least
and then acquire assets to start with, and then file bankruptcy and not have to pay all of your debtor, your creditors, and then have something left over, even if it's. And there are some things left over. I mean, exemptions. There's a federal scheme of exemptions which is fairly limited, but
they can't take the house you're living in,
and that's Texas and Florida have great unlimited homestead exemption.
The car you use to get around.
The car, and I mean in Texas, I mean I think it's a 200-acre ranch or a house on 10 acres. I think if it's inside rep. So I mean you could literally shelter 10 or $20 million from your creditors. If you have that house, have had it long enough that nobody can trace monies going into it that belonged to somebody else in the process. So there are examples of people that file bankruptcy that keep their house in River Oaks.
But there's also systems in place where people are appointed to kind of oversee, if not take control of your assets or your business, at least oversee the process and make sure the debtor's not doing something backwards, somehow gaming the system.
And there are
like a trustee gets appointed
in a Chapter 7 case, which is a complete liquidation. A trustee is appointed, and the trustee will do two things. One, make sure that all of the paperwork and disclosures and all the procedures are followed properly, and also to see if there's not some asset that the trustee cannot take and sell and give money to creditors in the process. And some of these assets include, not just the ability to sell, something that's not a principal residence or some stock portfolio or some other, what we typically think of an asset or a property of the estate, but also certain causes of action for things like fraudulent conveyances or transactions which involve the debtor having done something with another party that basically removes assets from the debtor's estate and puts them in the hands of somebody else. So typical example is if on Monday I owe the bank $10,000 and I owe my mom $10,000 and I've got $10,000 in the bank, then on Tuesday I give the $10,000 to my mom because I want to make sure she's taken care of. I don't care about the bank. And then on Wednesday I file bankruptcy. Well, the bank might say, well, that's not fair. I mean, you showed preference to your mom. Your mom is an insider or a relative, and immediately before the bankruptcy, you distributed all your assets, and now there's nothing left for us. So that allows then a trustee to basically sue mom as the recipient of a fraudulent conveyance and make mom put the money back, so that the money can be divided up amongst creditors who have what by the rights that they had before the transfer was made.
Poor mom. Don't do that to your mom.
Well, I'm not sure that's true. They might be able to get away with it. I mean, I owe mom $10,000. I paid it. I mean, that's and we don't do it Monday, Tuesday, Wednesday. I mean, the trick there would be to do it and then a year later, file back.
Well, and another thing is probably kind of tangential, but if you do like legitimately, borrow money from your mom, maybe actually like
Yes,
have it
that's true. That's
documented,
true. And give mom a security,
promissory note or
and a
something.
security interest in something in the process. Give her collateral in the process because it protect your mom from your other creditors. Now, your other creditors may already have liens on it, and your mom may just be giving you the money because she
She
wants
loves
to
you.
help you in the process. So that's how relatives typically they lend money are generally speaking don't do well in bankruptcy because they're considered insiders and they also are less likely to have properly secured their debt in the process. So that's
Bringing it back.
all right.
Bringing it back. So that's chapter 7 is liquidation.
Right.
There is something called chapter 5.
Well, no,
Which
chapter
11 and
chapter
then chapter 5.
11, which is a subchapter. So chapter 11, business bankruptcy, where the idea is that we're going to let the business continue to operate. We're going to pay the creditors some amount of money over a plan, and typically you see 3 to 5 year plans.
Right. Okay.
Sometimes you see liquidation plans where we're basically going to keep this business operating. We're going to sell it to somebody. We're going to sell the assets to somebody, but we don't want to just shut it down because that loses the ongoing value of the business.
I want to rewind a little bit.
All right.
Chapter 7 is individual bankruptcy.
No, some corporations too.
Oh,
yeah. So
is it? But that's all.
But that's all.
Can an individual keep going, so to speak? Does an individual?
Yeah, the individual can't. The individual can't. No, the individual can have file a chapter 13. I'll get into that in a minute, which is what they call wage earners workout.
Okay, got it.
And also, an individual can file at chapter 11.
Okay.
I remember, John Connolly, former governor of Texas, former secretary of the Treasury, made some investments in the 80s that didn't turn out well, and he filed a personal chapter 11 of $100 million worth of debt that was reorganized in the process. So individuals, I think Dr. Denton Cooley, again, a bunch of people back in the 80s filed kind of big, $100 million chapter 11s. One of my former employers.
I guess maybe it's people like this that if you're going to file bankruptcy, us in the middle to lower class are like, but you still come out okay on the other end. It's not like they lost everything and we're destitute.
Yes, but at the same point in time, their creditors got something that without the bankruptcy process they might not have gotten.
Okay. So I don't necessarily want to go into all the different types of bankruptcy, because if someone does need to actually file bankruptcy, they're going to need some guidance as to which one they need to file into. This is not something we would advise someone to just take on.
No, I'm generally speaking advise people try not to do it. So
that brings me to, who is bankruptcy right for? Because there have been some clients who've come in and said, we need to file bankruptcy. And you said, no, not really. I would advise against it. So who is bankruptcy right for, and who should avoid it even if they find themselves, stinking and with lots of creditors to pay, they've dug themselves in and think that the only way out is bankruptcy.
And there are people that are so far that they're never going to get out. So far, so deep. I mean, there are people that I know that have $100 million worth of debts, and they're older, and maybe they used to make a lot of money, but they can't anymore. And I mean, they have some future earning potential, some assets that are exempt. They're getting hounded by creditors. Creditors are, trying to collect, trying to garnish their bank accounts. Makes it difficult for them to get a bank account and operate out of a bank account.
Okay, so in that case, those would be people that bankruptcy is probably right for.
Right. And then there are people who have a business, entities, companies that can't pay all their debts because something happened in the past. I think we're going to see a lot of this with office buildings. The office buildings, are not worth what they used to be post-pandemic. Particularly suburban office buildings. And a lot of them have mortgages from days when office buildings were more expensive, and the owner bought it, got a mortgage, and now it doesn't have the same cash flow, doesn't have the same occupancy that it used to have. Now, but it's still there. It still exists. It's already built. Nobody has to build it again. So it will be able to charge some rents and to pay some mortgage. But so a bankruptcy that restructured that debt, may give an opportunity for the people that work for the building and the people that own it, to have it, and the creditors, to have some continuing cash flow rather than doing what we did or what banks did in the 1980s, which is basically foreclose on all the real estate in Houston, which was just horribly disruptive to the
Yes.
market. And those institutions, mainly savings and loans back in those days, were later had to be shut down by the government in the process. So there's a little more order to the process, which a bankruptcy can create. I mean, I guess a small store that somebody ran that got into bad debt situations, but it still can be profitable going forward if it can settle.
So who would you not recommend bankruptcy to, who thinks they might need it?
Well, somebody that could work things out without that. Somebody who has a limited number of creditors that they can work with. Shouldn't file bankruptcy. They should sit down and try to work it out outside of bankruptcy.
Bankruptcy is long and cumbersome, and it has a lot of.
It can be. It can be. And there are some people who owe a lot of people a little bit of money.
There's a timing aspect too with bankruptcy. I
Yes.
know that, let's say there's statute of limitations that we work with maybe debts, for example, debts to the IRS. That if the IRS doesn't collect on it within a certain amount of years.
10 years usually.
But
yeah.
like however long you're in bankruptcy, it pauses that.
Yes.
And it's the same with other statutes of limitation with certain
yes,
certain debts.
that is. So if there are, like I said, if you owe a bunch of people a little bit of money, not everybody's going to try to collect. And some of those debts, may run out because of statute of limitations. Some other debts, may last longer. But the idea is, if I would hate to have somebody, file bankruptcy the day before the statute of limitations ran out on a $200,000 debt.
Yeah, don't do that.
Definitely
know when the statute runs, and don't do that.
And that's not necessarily easy to figure out, because it is, generally speaking, 4 years from the last default. So have to look at each of those debts and figure out when the last default was. But that's something to keep in mind. Is a bankruptcy would allow I won't call lazy or dormant creditor to wind up collecting some money that they wouldn't otherwise collect.
Okay. And I do want to stress, and I think we're probably going to need to do like a few more topics on this, just so that the point is made. There are a couple of debts that do not get extinguished in bankruptcy. Nothing like, and there are
more than a few, but I mean there's generally speaking trust fund taxes
for employment.
Employment taxes, excise taxes, or sales tax, where the idea is, at least theoretically, the debtor collected the tax like in a sales tax, and is supposed to turn it over to the government, usually state government or local government, and doesn't.
Collected on behalf of the person paying, the customer, or the employee.
Right. And in that case, those debts are not discharged.
And you can be held personally liable.
And the person all the people who were involved in that process, the officers, directors, people who have signature authority on the bank account,
people who may have known that the payroll taxes weren't being paid and had some authority,
or should have known
and did nothing. Yeah.
So that's one. Also, I mean, I think like drunk driving liability is not dischargeable. Child support, alimony are generally not dischargeable. Certain intentional acts are not dischargeable. So I mean, I guess the case that we were involved in, there was a libel, slander, type of thing that was considered an intentional act, and the individual was not discharged. As a result of that. So there are things that cannot be discharged. I think the O.J. Simpson case is one that you know, O.J. Simpson probably couldn't have filed bankruptcy because he was held liable for the wrongful deaths of Nicole Simpson and I'll forget the guy's name.
Yeah, I mean, I
Yes,
was alive
yes,
at the time, I promise.
yes,
But
yes,
you know,
yeah.
and I remember all of that.
Yeah,
But again, we're going off on a tangent. Okay, so bankruptcy is right to file for some people. Others
Yes.
you would recommend not.
right.
And in some cases, some people file strategically, which we have, and you've kind of been on the flip side as a creditor, trying to foreclose or trying to, you know,
Yes,
help
yes.
creditors get some kind of, you know, the debt they're owed, and some people just say, well, I'm going to file bankruptcy.
And and they can buy time.
Yeah,
You know, and
and
if that's the only thing you're buying is time with bankruptcy, it's probably not a good strategy because it doesn't come out. You turn too much authority over to the courts and trustees to do things to you by filing bankruptcy that wouldn't happen otherwise. It can stop a foreclosure for a while, but I mean, if unless you have some way of paying the debt within that 90-day period that you may buy yourself, you're going to regret having done that, filing bankruptcy in the process. And that is a bankruptcy abuse, to file bankruptcy just to invoke the automatic stay to buy a little bit of time in the process. If there's really no hope to save the project or the asset or the business, filing bankruptcy is a bad idea.
okay. See, I knew you were the guy to ask all these questions because you pretty much had answers to all the questions I asked. But just to wrap up the topic, generally on the topic of bankruptcy, is there anything else that we haven't hit that
You know, it's a complicated area of the law,
Yes.
very strategic.
Yes.
Not in terms of whether you should file bankruptcy, but when you should file bankruptcy, what you should do before you file bankruptcy.
Yeah. And all the
of that-
processes involved
all of that,
once it is happening.
strategic, and it's expensive. I mean, you know, it's sometimes I tell people it's just cheaper to pay your debts.
Yeah. Just figure out a way to do it.
That's not those people
Make
have
a plan.
$100 million worth of debts, but I mean,
Right.
you know, I have some people come to me that they have $50,000 worth of, and I'm just not sure it's worth filing bankruptcy.
Just make a plan.
Yeah.
We can make a plan together.
All right.
Okay. Thanks, Hap.
This is Hap May with a Legal Play.